Hello, this week we're talking about what it's really like for your family if you do not have an estate plan, whether it's a will or a trust in place when you pass away and you're said to have died intestate. So this is episode 46 of Estate Planning Weekly. I am your host, Don Rolfe, the owner and founder of Northwest Legal Planning, an estate planning and probate law firm located in West Linn, Oregon. So what is it like for your family or the people you leave behind, whoever are going to be responsible and take care of your estate after you're gone, if you do not have a will or a trust? Let's just say trusts are out of it and you don't have a will, right? So if you had a will, that will would be probated and you could make some decisions in there that would make the process a little bit easier for the person processing your estate through the probate. But if you don't have a will, these are the things that are going to come up that are going to be sort of a roadblock. Number one, something that I'm dealing with right now is we have an intestate probate that we've just filed, and prior to filing it, we needed to get consent from the other heirs, generally the other children, so that one of the sons could be the personal representative. So there's some time and some effort involved in getting those consents signed. If we did not, or we were unable to get those consents signed, we would have to file our petition with the court to open up the probate without a will. We would then have to send notice of that to all of the people that we could find that could potentially be, could raise an objection to the appointment of the person filing the petition, and then wait 14 days from there. If we receive no objection, then file something with the court saying that we received no objection and please will you enter a judgment appointing the petitioner to be the personal representative. One of the things that that petitioner will now have to do most likely is also post a bond. A bond is sort of like an insurance policy that the petitioner will have to pay for to post it with the court to say, to protect the assets of the estate and protect the rights of either the creditors of the estate or of the heirs, to make sure that that personal representative isn't going to be absconding with funds. So those are a couple of things that are going to happen if you die intestate, that your personal representative, whoever it is that decides to step up, is going to have to deal with. And that brings me to the third thing that I wanted to talk about, is who is going to be your personal representative. If you don't choose one in your will, then pretty much anyone that has any interest in your estate could be your personal representative. So I have served as personal representative for an estate where I had no relation to the decedent, but I was hired by a creditor, the mortgage holder on a house, to open up the probate and for me to be appointed as the personal representative because they needed someone to serve in order to foreclose on the house. The person who passed away had passed away, I think, about 8 years previously, so the house had just been kind of sitting there with the bank owning it but not being able to do anything because there was no one to serve with the foreclosure proceeding. So even a creditor can become your personal representative. It just happens to be whoever steps up into that role and makes the initiative to become the personal representative. Not saying that that's common, that creditors become PRs, but it can happen. So essentially, if you're not putting together an estate plan of some sort, at least a will, you're going to be putting, you're not going to know who your personal representative is going to be. The process of getting your probate opened is going to be a little bit slower and more cumbersome because we're going to have to get more consents and those sorts of things and find someone who wants to be your PR to begin with. And then also there's going to be the requirement of bond. Now, bonds generally aren't that expensive, but it depends on how much of a bond the court wants it to be posted. So those are, three things functionally that would be different. And then the last thing I want to talk about is, before I get there, if you have any questions about this or any other estate planning topic, do feel free to reach out to me. You can go to myestateplanmeeting.com and get yourself right on my calendar for a complimentary estate planning strategy session. Okay, so the last thing I want to talk about is then you don't get to decide who gets your things and how much of your things they get. It's going to be all dictated by statute. Generally, your spouse would get everything. If it's a second spouse and you have children from a previous marriage, there's going to be some splitting up where your children from the previous marriage are going to be getting their portion. If you have children, you could have children that you would never want to leave anything to, or other family members that you would never want to leave anything to, but because they fall in the right order in the statutes and laws of the state for intestacy division of your assets, they're going to inherit from you even if it were your choice never to do so. And if you have minor children, the will is where you name who you want to be guardians of those children. And if you haven't done that, then people are going to step forward and petition the court to become guardians. There could end up being a fight, and the ultimate decision as to who will be the guardian of your children is going to be with that judge. Not that judges make poor decisions, but judges don't know your children, they don't know you, they don't know your values, and they're going to be making the decision based upon what's on paper and some testimony, not upon your intimate knowledge of your children and the people that you would want to have raised them. So again, if you have any questions about what it's like for your family or your loved ones after you pass away, if you do not have an estate plan, or this is prompting you to maybe ask some questions about maybe wanting to get an estate plan, do feel free to reach out to me. Talk for a half hour, absolutely free, by going to myestateplanmeeting.com. Put yourself right on my calendar, either for a phone consultation or in person, and I really would look forward to seeing you. So, that being said, if you like this content, please hit the like button, leave a comment, share it with your friends if you think that they would enjoy this content as well. If you are listening to this on a podcast, if you could go over to iTunes and leave me a review, I would really appreciate it. Or just a rating. I assume that if you're listening to this, you like that, leave that 5-star rating, or leave me a review. Let people know what it's like listening to this podcast. Same thing over on YouTube. If you like it, give me a thumbs up. Let people know that this is content that you enjoy consuming. Again, my name is Don, owner and founder of Northwest Legal Planning. Until next time, take care. Goodbye.